A very good afternoon to our chairman, sir, CA Vishal Doshi ji in absentia, joined by our very own CA Pramod Jain, sir, vice chairman to the committee. He is physically present with us. The speakers for the day, Professor Dr. Salina Bashir ji, Miss Nazia Fatima ji, and we are fortunate that we are joined by Dr. Ashok Mishra ji also. And to our worthy members who have joined all across for this engaging session on which we'll be discussing on revitalizing India's landscape, analyzing obsolete economic and commercial laws for Viksit Bharat 2047. This particular topic, this particular research has been carried out by our worthy speakers, Dr. Salina K. Bashir, who is a professor and dean of Hamdard Institute of Legal Studies and Research, Jamia Hamdard, an accomplished research scholar in intellectual property law, and has served as an IPR chair professor and is widely recognized for her contributions to copyright, technology, and environmental law. Our speaker, Nazia Fatima, she is a faculty at the Hamdard Institute of Legal Studies and Research, Jamia Hamdard. Her core areas are labor law and alternate dispute resolution. Her research and academic work focuses on labor rights, workplace justice, mediation, arbitration, and involving ADR frameworks. I welcome you, both of you for this engaging session. As the topic is really very engaging on obsolete and commercial laws for Viksit Bharat 2047, we'll be discussing on various obsolete laws, the laws which are already prevalent but are redundant and obsolete. The researchers have done it through a engaging literature review, the surveys which will be shared by our speakers of the day. Now I request our Vice Chairman, Sir, C. Pramod Jain, Sir, to please share the opening remarks. Sir, please.
Thank you, Dr. Mitali. Namaste to all. Welcome everyone who are watching this live. Our third episode, our third webinar on Anusandhan, bringing the new insights. My chairman, who could not join today due to certain issue, basically he's out of country and the timelines are a bit different. And of course, this third webinar on this Anusandhan is on a very, very important topic, which is revitalizing India's legal landscape. That is, analyzing obsolete economic and commercial laws for the Viksit Bharat at the rate of 2047. Friends, this has been the thought process of our chairman, that the research which is being done and published by our institute, let that be known to public at large and members at large, that what is the intent and what is the outcome of this research. So I extend a warm welcome in absentia to, of course, my chair and also the renowned speakers, as Dr. Mitali also told, Professor Dr. Selina Bashir and Dr. Nazish Fatima, and also Ashok sir. This research committee is one of the most experienced committee of ICAI, which was established way back in 1955. Since then, it has been committed to fostering a research-oriented culture with continuously enhancing the quality of professional service for the benefit of fraternity and the nation as a whole. This committee, the research committee, is pleased to launch, of course, our this dedicated webinar series. This is the third one in showcasing our latest published research reports. This initiative to bring the technical findings, the analytical perspectives, all these directly to our members and public at large, I would say, fostering an environment of continuous professional learning. The report, which is being discussed today, shared today, emphasizes the need to review outdated economic and commercial laws to ensure that India's regulatory framework remains conducive to ease of doing business, innovation, investment, and sustainable economic growth, in line with the vision of our government of Viksit Bharat at 2047. This report presents a structured and evidence-based framework for identifying obsolete, misaligned, and reform-worthy economic and commercial laws, drawing on stakeholders' insight and global best practices. Also, this report proposes practical pathways for legal modernization to support India's transformation into a developed, technology driven economy by year 2047. I am very confident that this report will contribute valuable insights towards the India's legal and economic transformation. Through this expert analysis and practical insights, participants will be able to gain a deeper understanding in this webinar. I wish everyone a very, very knowledgeable and learning productive session. And of course, those who are watching it right now, very, very good, and they can inform others. Those who are not able to watch, I'll request those who are currently participating into this virtually, they can tell other members that they can see it anytime later on also through our ICAI TV. It would be there permanently, so anyone can view that at any time. My best wishes and a happy learning for this 2 hours sharing session of our research report. Thank you very much.
Thank you so much, sir, for sharing the insights and few quick things about the report, how the report has been dealt with, and how what will be bringing out of this research, and the about the series and the vision of the chair and vice chair both. So, not taking much of the time, I request our speakers of the day that they may please initiate the discussion and let our participants also get the benefit of this research work.
Thank you so much, Dr. Mithali. Thank you so much. Mithali, so what about the slides, how it will be moving? The PowerPoint, who will be running, who will run it?
You will run
You are
yourself,
sharing,
ma'am.
I'll do it.
Nazish,
Yes, ma'am. I'll do it.
you will be sharing the screen.
Yes, ma'am.
Oh, thank you so much. So let me begin. On July 1st, 2017, at the foundation day of this institute, just after the dawn of GST, the Honorable Prime Minister looked at the CA fraternity and said, "Your signature is more powerful than that of a Prime Minister. Your signature is a testimony to the trust in truth." With that single line, the Honorable Prime Minister rewrote the story of nation building. If the first struggle of freedom was led by lawyers who fought for political independence, the Honorable Prime Minister was telling us that the next struggle would be led in the ledger and law by the chartered accountants who must secure economic independence. The dream of Viksit Bharat is nothing but the second freedom struggle, a Bharat whose growth is honest, whose wealth is inclusive, a Bharat whose prosperity rests on clean books, fair markets, and fearless professionals. Ya Esha Sukteshu Jagradi, Ya Esha Sukteshu Jagradi, the one who is awake while others sleep. This line captures exactly what the role demanded by Honorable Prime Minister: to stay awake when others look away, to guard the Republic's economic conscience when it could be easier to compromise. For more than 7 decades, ICA, the CA fraternity, has carried that torch with quiet dignity. Today, this spirit has a very practical expression. ICA is carefully looking at our economic and commercial law to ensure that they are in tune with the country's journey towards Viksit Bharat. Namaskar, good afternoon to the Honorable President, to the Honorable Vice President, esteemed Central Council members, Honorable Secretary of the Institute, the Honorable Chairman, CA Vishal Doshi ji, Honorable Vice Chairman, CA Pramod Jain ji, respected members of the Research Committee of ICA, my esteemed colleagues, and to all the distinguished members of the profession and academia joining us from across the country. It's both my honor and my responsibility to stand before you today. I'm Professor Salina Bashir, Professor and Dean, School of Law, Jamia Hamdard. I'm deeply honored to be with you this afternoon as part of the Research Committee's series Anusandhan, bringing new insights, ICA research insights and findings. I'm joined by my colleague, Ms. Nazish Fatima, and together we had the privilege of leading this ICA-sponsored research project. At the outset, I wish to express my sincere gratitude to the Research Committee of ICA under the leadership of CA Vishal Doshi ji and CA Pramod Jain ji for entrusting our team with this work and designing this platform to share the Your commitment to treating research not as a formality, but a serious instrument of policy influence has shaped every stage of this project. I'm equally grateful to Dr. Mithali Pathak, Secretary to the Research Committee, whose meticulous coordination and tireless support have been indispensable to the progress of this study. And I must place on record my deep appreciation for Dr. Ashok Kumar Mishra, who has been a strong pillar throughout his guidance, probing questions, strategic insights. From the framing of our research question to the sharpening of our recommendations, Dr. Mishra have substantially strengthened the intellectual core of this work. Thank you so much, Dr. Mithali and Dr. Mishra. On behalf of School of Law Jamia Hamdard, we will be presenting this project today, and this is the title as you have seen, Revitalizing India's Legal Landscape, Analyzing Obsolete Economic and Commercial Laws. This is not mere a title, it is a question. It is a question which we have to ask ourselves. Can we truly become Viksit Bharat if the legal scaffolding of our economy still carry the weight of a different century? Still, if the legal scaffolding belongs to a different mindset, if the legal scaffolding belongs to a totally different world. So I'm repeating the question. The question is, can we truly become Viksit Bharat if the legal scaffolding of our economy still carries the weight of a different century, different mindset, and a different world legal framework? I therefore offer my most respectful gratitude to the leadership of the Institute, to CA Prasanna Kumar DG, the President, whose visionary stewardship carry ICA towards global beacon of excellence, integrity, and public trust. To CA Mankesh Panduran Kinariji, the Vice President, whose steady commitment institutional framework set a gold standard for professional governance. And to CA Jay Kumar Batraji, Secretary, whose scholarly and precise hand keep the engine of this institution running with discipline and grace. And once again expressing my heartful gratitude to the Vice Chairman, who has understood our whole project and has summed up, and for the trust and confidence you have given it with us. Thank you so much, sir. You gave us the trust, and we have tried with every ounce of effort to be worthy of that trust. I also record my deep appreciation for the research members, research committee members, and also to my co-researchers, Nazish Fatima and Mr. Jahangir Badar, without whom not a single page of this work would exist. To all of you, I do not merely express gratitude, I express reverence. So looking at the title once again, as we know, India is already the world's 5th largest economy, on a trajectory to become the 3rd. To reach the Viksit Bharat 2047, our GDP must multiply many times over. Our per capita must rise from a roughly low middle income level to developed economy level. These are not abstract aspirations, they are hard arithmetic to say. Arithmetic of that kind needs infrastructure, not only roads, ports, or digital platform, but the invisible and the most strong infrastructure of law. The statute that governs contract, banking, corporate structure, everything needs total revamping to meet the demands. Our task in this project has been to support the choice of this institute because they saw the obsolescence as a major obstacle. ICA saw it earlier than any other institution, and ICA chose to act. So our task in this project has been to support the ICA's initiative in economic renaissance of India. In the next 2 hours, we would like to do 3 things with you in a clear and an orderly way. First, we will share what a broad section of practitioners from across India, chartered accountants, advocates, judicial officers, CMAs, company secretary, MSME owners, and even the academicians have told us about where in their day-to-day work, India's economic and commercial laws feels outdated, where they feel the economic and commercial laws are overlapping or out of step with the contemporary business realities across 12 sectors. Secondly, we will explain how we have brought these voices together through a single lens called the Obsolete Diagnostic Framework. We have developed a particular tool, a measuring tool, which we will explain as we move on, which applies a 5 straightforward questions to each statute and then places it In one of the three categories, we have classified the laws into three, A, B, C. The laws that has to be repealed, the law that should be consolidated, the law that ought to be modernized. Then we will outline the concrete outputs through the research, a working, and we are coming up with a redraft of the Indian Contract Act 1872 and a practical proposal how ICA can use the tool which we have developed. The tool, as I mentioned, the Obsolete diagnostic framework. It is a kind of an MRI scan, or it is a kind of a constitutional stethoscope, which you can apply to any statute to ensure that whether it is healthy enough to meet the Viksit Bharat 2047 journey. Nazish, now I'm on the third slide here. So why ICA commissioned this research? How this obsolescence, of course, reformation of law, we have the Law Commission, we have the Niti Aayog, we have the Department of Legislature. Why ICA have this mandate, have initiated this mandate? Of course, the first thing is that it is a real life or lived reality of ICA members. A single MSME client coming to a CA, he has to comply with more than 1,450 separate regulations every year. And regulators issue about 42 new changes every single working day. Chartered accountants absorb this churn first. ICA needed proper documentary evidence of which obsolete provisions are creating that load. Secondly, we can see that there is a national policy vacuum. As we know, since 2014, the government has repealed nearly 1,500 central laws. Yes, but India still has no systematic, structured framework to detect obsolete economic, commercial law on an ongoing basis. We are saying that it is not an exercise which have to do at a one stretch in a particular day or in a year, but it is a continuous process. Because the obsoleteness of any particular, the relevance of a particular statute should be continuously assessed. So by sponsoring this research, ICA has positioned itself to fill that vacuum. And third, the only chartered accountants are the first person, the first custodian who stand between the economic laws or the corporate law and its actual complaints. ICA is uniquely placed to have converted that practitioner intelligence into structured policy input. Like Niti Aayog or Law Commission to MCA or to Ministry of Finance or RBI and SEBI. So ICA can bridge that gap with this project report. So as we move to the next slide. And if I want to, or if me and Nazish want to compress the entire research project into one sentence, you look at the screen, this is the question. Which of India's pre-2014 economic and commercial law still earn their place on the statute book, and which ones are silently taxing the economy, the profession, and the country's 2047 ambition? So our answer will come in three pillars. First, we will identify obsolete and misaligned statute across 12 sectors. We diagnose them using a structured 5 criteria framework, which we have built, as I already mentioned, or obsolete diagnostic framework. And we recommend for each statute whether the right action is repeal, consolidation, or modernization. So to say in simple words, we will be asking one question, that to what extent the economic and commercial law are in tune with our journey towards Viksit Bharat. Then we will identify them with our tool which we have designed, obsolete diagnostic framework. With the tool, we will classify the laws into A, B, C, those which have to be repealed, those we have to be consolidated, and those needs updation or modernization. So this is the whole exercise which we have done throughout the project. So coming to Viksit Bharat, the next slide. As we know, the target of 2047, it's really huge. India's economy today is roughly 3.36 trillion US dollar, but the 2047 target is 30 trillion. That is 9 times the multiplication. Per capita income has to increase 8-fold from roughly US dollar 2,400 to US dollar 18,000. And it's really a big figure that no country in the modern history has achieved that scale of growth on the top of a legal system written for a different era. So the question is not whether the legal reform is necessary. It is whether and at what time, on the right time on which we have to do the reforms. So what is this 2047 vision demand from the legal infrastructure? 4 things. We have to lower the transaction cost. We have to reduce the complaints overheads. We have to ensure legal recognition of digital first commerce, fintech, e-commerce, smart contracts, and AI. We also have to align our domestic system with global standards set up by WTO or OECD or UNCITRAL. And we have to ensure that our legal framework is predictable. There is time-bound dispute resolution. Every one of these touches the daily work of a chartered accountant too, as you know. As we move to the next slide, this is the crux of our study. That's what is obsolescence? Or we want to define obsolescence in the context of our study. Let me define it. It is statutory obsolescence simply means a law is still in force. Okay, it doesn't mean that there is a law. But the social, economic, or technological reality it was written for has been fundamentally changed. And suppose, for example, the Carriers Act, which we have designed for a period of bullock cart. Now, what is the fast track trains, the metros and all, how the Carrier Act is applicable. Similarly, the Stamp Act, when we had the concept of having only paper, document means only paper, and signature means only ink. Now, total change of the digital technology. So the law still imposed the compliance, but it no longer delivered the regulatory benefit it was designed for. The law is there, but the objective, the purpose, or the legislative intention which it was having at the time of enactment fails now because the regulatory benefit means the purpose, the scenario, socio-economic political scenario has completely changed. So an obsolete law, according to our definition, will have 5 characteristics. It has lost the relevance. It may conflict with some other newer statutes. It persists because of inertia. It is not useful any further. It sits inconsistently with the rest of the legal system, and it frustrates justice because complaints cost outweigh the benefit. So I'm repeating it. What is obsolescence according to us? We will say that a particular statute is obsolete if it failed to meet the regulatory intention for it was designed for. It has lost the relevance completely. It conflicts with a newer statute. It has become completely non-useful. It is continuously inconsistent with the rest of the legal system. It frustrates the justice because complaints cost outweigh the benefit. So now we can see that the Law Commission reports 248 to 251 identify nearly 288 central laws as obsolete on doctrinal grounds. But that was a top-down paper-based exercise. It catches textual level obsolescence, or in paper or in theory. But it missed the perceived obsolescence. Suppose, for example, what a chartered accountant has to do in his day-to-day affairs. They have not penetrated to that day-to-day affairs of a chartered accountant to say. So law still active in complaints, but the practitioners consider it as redundant or burdensome. So as we move to the next slide, we can see that the complaints burden. For example, a medium-sized Indian firm faces more than 69,000 regulatory obligations across 1,500 plus central and state statutes. I'm repeating the number. A medium-sized Indian firm faces over 69,000 regulatory obligations across 1,500 plus central and state statutes. So a single manufacturing MSME complies with more than 1,450 regulations a year. It maintains on average paper or digital books. The annual complaints cost for one MSME is between rupees 13 lakh to 17 lakh, completely disproportionate for a small business. So how the people will come up with initiatives. In the financial year 24-25 alone, the regulators issued 9,300 changes, roughly 42 every working day. And in MSME labor law alone, there are 486 separate provisions that carry imprisonment, criminal liabilities, and all. So finally, what we have to do? There is a cost imposed on us. The cost in 3 different ways. Of course, financial burden is there. Loss of the professional time. Firms simply refuse to scale past certain employee count because the moment they cross a particular threshold, a different layer of compliance kicks in. And CA profession sits in the middle of this, absorbing the cost in client on one end and serving time and absorbing the risk in audit liability at the other end. So as we move to the next slide, we can see that, as I mentioned, the Law Commission has tried a lot of reform. Before this research, the conversation on legal reform in India was dominated by top-down repeal projects like the Law Commission 288 statute through the doctrinal analysis. The Jan Vishwas Act decriminalized 183 provisions across 42 Central Acts. Niti Ayog's working papers for broad rationalization. With this center, Maharashtra study revealed 125 pre-independence statutes still on state books, and OECD diagnosed that India lacks a coherent government-wide regulatory. So we are not claiming that our work is a kind of a novel, unique, and one of a kind. No. How our work is different from the previous exercise on legal reform is that, as I have already mentioned, they followed a textual and a theoretical kind of repeal. So all those reforms are excellent, but it's all top-down. The missing piece, what this research we are trying to supply is bottom-up, a criteria diagnostic that we apply to 33 statutes across the 12 sectors backed by direct empirical evidence which we have collected. We give you sector-by-sector classification as a proof of concept. We drafted a section-by-section reform of even Indian Contract Act. Let me now introduce this concept of obsolete diagnostic framework. Because let it be me or Nazish, both of us will be very frequently using this term ODF or obsolete diagnostic framework. And I believe we can take the pride that it is we who designed it. And we designed it for statutes like an MRI is for a human body, a high resolution measuring device that reveals whether an economic or commercial law is still healthy or quite becoming a liability on India's statute book. Or otherwise, the diagnostic framework which we have developed is a kind of constitutional stethoscope for an economic legislation, a precise instrument that tells us whether a law's heartbeat is still strong enough to justify its place on Indian statute book. So the framework or the MRA is a kind of toolkit, a measuring device which we have devised will tell you whether this particular law still healthy to be placed on Indian statute book in our journey to Viksit Bharat. As we move to the next slide, it's our project in a glance. How our methodology to say, research methodology to say. We did a triangulated mixed method, doctrinal, comparative, and empirical, all 3 integrated. We surveyed stakeholders, nearly 137, from all, like from judiciary, from academicians, company secretary, CA, and we covered 12 sectoral law clusters. We benchmarked 8 foreign jurisdictions also. We developed a 5 criteria ODF, as I'm saying, and we produced as a working output, section by section reform of Indian. Sorry, there was a little bit of repetition, but this is the whole project we have done. Now, coming to the objectives and research question. The project had 4 formal objectives and 5 research questions, which we have discussed in chapter 1 of our report. You can see on the slide also. Of course, the essence is examining Viksit Bharat's commercial law dimension, compile a database of pre-2014 statutes that conflict with Viksit Bharat agenda or Viksit Bharat journey, drawn on international best practices and build a structured framework for evaluation. We have chosen the international jurisdiction based upon a similar kind, just like, the Saudi Arabia, the Kingdom of Saudi Arabia or United Arab Emirates. They have this Vision 2030, Vision 2040. So we have chosen that kind of jurisdiction where they also have this kind of target like Viksit Bharat 2047. So in the next slide, we will be explaining further our research methodology. It's just, as I have already mentioned, doctrinal. The first was doctrinal mapping. We mapped every central statute in our 12 cluster, looked at the amendment, the Law Commission reports, Niti Aayog papers, OECD assessment, and the academic literature. And then we moved to the comparative leg, where we have chosen Japan's competition law evolution, Singapore's regulatory sandbox, New Zealand's stewardship model, UK's planned obsolete reform, EU's RFIT program, US sunset review, Saudi and UAE Vision 2030 codification. Then we move to empirical lag, that is a structured Google form where we have went to the field, collected data from the practitioners through sampling techniques, and then we process the data through the sampling technique. Then we all three legs fed into our diagnostic framework, which gives every statute a category A, B, or C. That is the backbone of our chapter 4 too. So with these words, hereafter it will be our empirical study and a detailed explanation of what we have done. Will be taken, Ms. Nazish Fatima, my co-researcher, will be taking over from here. Thank you so much. Nazish?
Thank you so much, ma'am. Good afternoon, everyone, and thank you for staying with us so far. So, should we begin with a slide? Slide 12. So I start with slide 12, that is. So, ma'am has already done the most important thing in any research presentation. She has actually given you a background and told you why we did this study and how we designed it. My job here for the next 45 minutes or whatever it is going to take you is to show you what about the project. What did we actually study? Who did we listen to? What did we build? And most importantly, for a room full of CAs, what reforms are we proposing that could change the law sittings on your desk every single day? I'll take you through three things in this section. First, the 12 sectors of the law that we examined. Second, the diagnostic tool we built. We call it the ODF, as ma'am has already explained, which is honestly the most important thing this project has produced. And third, a fully drafted reform of Indian Contract Act 1872, which we have called as the annexure here. Stay with me. Some of it will be technical, but I promise you it will be good that you listen to it and how practical it is. Like ma'am said, it's bottom-up procedure. The 12 sectors that we produced. The 12 sectors that we produced is the 12 clusters of law. I'm not here going to read all the 12 laws, but I'm just starting you with a simple example. Imagine you are a CA. Tomorrow morning, a new client walks into your office. He runs a fintech startup that lends to MSMEs. This is first. And he has a side business exporting masalas to Dubai. This is second. And his uncle has just left him a piece of family land that he wants to develop. Now look at the screen with me. The banking and finance is here. Yes. The foreign investment and trade is here. Yes. The infrastructure and land is here. Yes. Trade and commerce because of the contracts is here. Yes. MSME because he was lending. And then finally e-commerce because of the digital platform. These 5 of laws in the 12 clusters before one client. All of these laws being dealt by the CA in one go, right? So, this is what we have studied: banking, corporate securities, trade, insurance, IP, infrastructure, foreign trade, e commerce, MSME, and a miscellaneous bucket for things like Stamp Act and public debt. Now look at the last style. That one says excluded by design. This is important. We deliberately left out labor codes and tax laws because government is actively reforming both of these right now, and we left out also the Consumer Protection Act because it's too new to be fairly judged for obsolescence. In short, 12 clusters, about 60 central economic and commercial laws. That is the universe of our study. Now we move to the next slide. The next slide, that is the respondent slide number 13. So the next slide is who we listen to. These 137 people that we talk about. Since we had this research only for a short duration of period, that is for a 6 months time. Now this part of research, we have come up with 137 people who actually live with these laws every day. Let me give you a mix of all of these. About 42 of these people, 137 total, they were legal professionals such as advocates, judges, in-house counsels. Out of them, 26 were academicians, 18 were the chartered accountants themselves and cost accountants, 14 were company secretaries, and 22 were MSME owners, entrepreneurs, and industry professionals. And about 15 advanced other professionals we consulted. So, this is the exact mix of 137 people that we consulted, that we talked and discussed through and through about how and what are the things that are actually wanting the change. Now, why did we want this exact mix? First, the Companies Act of 2013 overlaps so heavily with SEBI rules, the IT Act, the CSR rules, and tax laws that audit risk has become genuinely ambiguous. Secondly, the MSME Act has a delayed payments mechanism that looks beautiful on paper, but in practice, the enforcement is weak. Buyers know it, sellers also know it. The third, for example, the Stamp Act that we talked about, different stamp duties in every state, fragmented interstate contracts, complete chaos for anything online or cross border. Fourthly, the Payment and Settlement Systems Act of 2007, which is actually a very rare law that might not everybody might be knowing. This law was written before UPI existed. We already use UPI for so much work. Now we understand that what is the relevance of Payment and Systems Settlement Act of 2007. Now, what we see for the researchers in our room, our sample is what we call as directional, or it is probability sampling. We, if given more time, we can replicate it with much larger sample size. Currently, we are keeping it to 137 because of the paucity of time that we had. Now, moving back to the next slide, that is, we are talking about the different countries, the 8 jurisdictions that we took. 8 jurisdictions that we took, that is the 8 countries, and 5 reform logics that we took out from these. The 8 countries that we looked at were Japan, Singapore, New Zealand, UK, European Union, US, Saudi Arabia, and UAE. Okay, so let's take 4 of them because each one represents what we call a distinct reform logic. The first one being Singapore. The Monetary Authority of Singapore created what is now famous worldwide, as we all know, the regulatory sandbox. Think of a sandbox, for example, a safe place where children can play without breaking anything important. Singapore said to its fintech startups simply, come, build, experiment in our sandbox. We will protect you and protect the consumers at the same time. The result? Approval timelines for fintech innovations went from 18 months to just 6 months. Fintech startups in Singapore grew by 245%. That is a huge number, right? Now, the second country that we are taking up is New Zealand. New Zealand has something called as a concept of regulatory stewardship. Since 2013, the government has a statutory duty to treat regulations like assets. For example, in India, our tulsi plant. You water it, you prune it, you don't let it die. Likewise, New Zealand did the same. Statutory duty to treat regulations as assets. In India, like we all know, we treat laws like a furniture and guest room. We put them in 1872. Now it has to be changed. The third country that we take is the United Kingdom. The UK has a planned obsolescence framework already. They mandate that manufacturers must keep spare parts available for 10 years. They deliberately retain some old rules even when they have known problems. Why? Why do they do so? Because the cost of full rewrite is higher than the cost of selective retention. That is sophisticated reform thinking, which we are trying to bring in us as well. The fourth country that we are talking about today here is the European Union. They have a beautiful principle called one in, one out. Every new regulation has to be matched by an old regulation that gets removed. Think about it, this is very unique. The European Union has a 37.5 billion euro burden reduction target. 37.5 billion euro burden reduction target. Indian regulators issue 42 new regulations a day with no target removal. So here we have to see that one in and one out. If we are putting up more regulations, we have to take the older ones out. The other four, the countries that I told just now, quickly. So, what is the quick points out of these four countries? Japan teaches us how competition law adapts to external shocks. US teaches us how sunset reviews force regulators to justify every few years why a law should continue. Saudi Arabia, for instance, and the UAE, as I mentioned these deliberately, because we usually don't look at Gulf countries. Uh, However, the idea is to show us that under Vision 2030, they have rewritten their entire commercial law architecture in less than a decade. They have a new bankruptcy law, they have companies law, commercial agency reform, all of it is done. So the honest takeaway from all these four jurisdictions is that no single country is a template for India, but at the same time, we can take different inputs from different countries, like Singapore's sandbox, European Union's one in and one out, US sunset law, which the Law Commission has already used, plus the UK's selective retention and the New Zealand's stewardship principle. If we blend those together, we get a real Indian framework. And that blend, anchored with our own diagnostic tool, which we've developed, ODF, is what we built, which brings me to the most important part of this slide or this presentation, which is what is our ODF flagship contribution. Now we're going to discuss what is this ODF flagship contribution for the next slide. The ODF flagship contribution, or the word says obsolescence diagnostic framework. In one sentence, it takes any economic or commercial law in India and answers a single simple question. All right, so what is this single question that we are going to do? Or where is this ODF built from? And before anyone asks, yes, we built this ourselves, but from where did we build this ODF? Where this framework came from? We synthesized the work from the different countries that I just mentioned, the 8 jurisdictions, the 8 countries that I mentioned, and what all the laws that pick one, pick out. All of this synthesized into one. The Singapore sandboxing, EU's refit model, US's sunset review, all of these countries, and then validated these framework. We validated this framework with the 137 practitioners that we talked about. So when I show you this ODF in the next slide, it's not a textbook framework. This is built from comparative evidence, and Indian practitioner reality. So it's a mix of comparative framework from different 8 jurisdictions and also with our Indian practitioners, 137 practitioners that we talked about. So since ma'am already mentioned that the 5 ODF criteria have, let's take it as a medical checkup metaphor. Whenever you go to a hospital, you have 5 health parameters where you see that okay, blood pressure is okay, sugar is okay. All of these things are criteria. So similarly, we have taken 5 health parameters for a law. Each criterion is a test the law has to pass. So now, what is the next slide says, what is this ODF? What are these markers that we have selected? Our 5 tests are: first, functional fit. A law has to be functionally fit. I'll explain you how and what do you mean by functional fit. Let's first see what are these 5 tests. Functional fit. Second is technological relevance. The third is economic impact. Are we burning rupees for these laws or is it useless for us? Or fourth is institutional alignment. Of course, most important, there is no overlap happening between institutions. And finally, the 5th test is global alignment. Are these laws globally aligned as well or not? So on those 5 criterias, we developed this basic framework. Now, functional fit, the first test that we talk about. Say, for example, take the Public Debt Act of 1944. Right? The Public Debt Act of 1944, the new thing that has come up, the Government Securities Act of 2006. It came along nearly 2 decades ago, that is the 10 years ago, meant to replace this Public Debt Act. But here's the catch. The 2006 Act didn't actually repeal the 1944 Act. It just said that the 1944 Act would cease to apply to most government securities. So the 1944 Act is still in our statute book today. Indian Code still lists at it as in force. It still has the residual application. This is the kind of exact zombie statute that we talk about, which are ODF flags. So it's functionally dead. It's no more functionally alive, but formally on paper, it is still alive. The honest fix here is to roll out it into a public finance management code and clear it from the books. This is what we have marked as category A, which will come up in the next slides. But then we are still moving into this slide only. We discussed functionally fit. Now we talk about technological relevance. Okay, so technological relevance, when we talk about, we have laws that govern smart contracts, AI-driven lending decisions, blockchain transactions, algorithmic markets, and all of these were written in the era of telegram and postal stamps. The IT Act itself was written before YouTube was invented, although there have been several amendments to it. But that is the technological relevance gap that we are measuring. We'll come up with different laws that have a problem as to technological relevance. Itself, the Contract Act, right? So that is the second criteria. The third criteria is economic impact. Economic impact is how far these laws are burdening us. Are we burning rupees to chase paise? This is the criterion CAs feel most directly. It is the cost of complying with this law proportionate to the regulatory benefit it produces. Or are we spending more on the compliance than we get back in protection? When an MSME has to follow, say, 1500 regulations a year, that is the economic impact question. So here, this is the third criteria that we are dealing, the economic impact of such laws. The fourth criteria is institutional alignment, like I said. Are different regulators stepping on each other's toes? It's like 5 mothers or 5 moms in one kitchen at the same time, right? So whose recipe is going to be the best and whose seasoning or whose masala is going to be the best? That is the question. This is what is happening when SEBI, RBI, MCA, IRDA, and CCI all have overlapping mandates on the same transaction. The institutional alignment criterion asks, is there clarity or is there chaos? That is the question that we asked for the fourth criteria, clarity or chaos, overstepping or overlapping of different regulators. The last criteria which we took in ODF was global alignment. So, global alignment means how far we are updated. Say, for example, somebody is coming to a 2026 party dressed up in a costume of 1990s. How far is it relevant? Similarly, does the Indian law fit with the international standards of WTO, FATF, OECD, UNCITRAL? Because in cross border commerce, if your law looks unfamiliar, foreign counterparties immediately charge you a mystery premium on every contract. That premium is real and it costs Indian business. So, therefore, this five criteria of FTEIG, functional, technological, economic assessment, institutional alignment, and global alignment, all of this, every law in our study went through this five diagnostic tests. Now, the question which we want to understand is, now we've discussed what is this ODF, right? We discussed from where it was derived, that is the eight jurisdictions that we talked about. Now, the important thing is that why this ODF matters long term. We used it for our study, but how it matters to be used by ICAI or for the CAs for long term. Now, ODF matters beyond this report as well. This is not a one time pill, this is a lifetime of gym membership that we talk about. The ODF criteria can be used forever for every new law, every old law, every reform or proposal. This criteria does not change, the methodology does not change, only the law is being tested against the changes. Just two of the six properties let me highlight. Say, for example, it is quantifiable. Each of the five criteria that we've given can be scored on a 1 to 5 scale. So, when we say a law is partially obsolete, we don't just say it, we score it. This is simplifying. This gives you a defensible number in policy debates. Second, it is plug and play. The ODF maps cleanly onto the workflows that Niti Aayog, the Law Commission, and various ministries have already used. So the submission becomes immediately usable, not rewritten, not translated, just plugged in. The four properties on the screen, they are replicable, they are stakeholder aware, they are internationally defensible, and outcome linked. They are all built on these strengths. So, an annual practitioner observations now have a structured channel to reach the policy. Now we come to the next slide. Now, I told you from where ODF comes or how ODF has been reaching, right? Now we come to, just a second, yeah, what ODF has produced. We discussed what is the structure, we discussed what is the background, we discussed why is it important, how it can be replicated. Now it's our study or what we have researched as to what the ODF has produced. Okay, so once it's like a school report card, right? How or the doctor diagnosis. Two parallels. Say, for example, school report card has A, B, C. You've got A in English, B in Hindi, all this like this. So once you put a law through ODF, what comes out? A classification. We use three categories A, B, and C, like a school report card, but for law, right? What are these A, B, and C? Category A talks about obsolete, the laws which have become obsolete, need a repeal, or need to be integrated. This is the law that has retired, but forgot to tell us the function has been fulfilled or superseded. It still imposes compliance cost but has no continuing regulatory purpose. The honest decision is to send this law back home. For example, like I discussed, the Public Debt Act of 1944. We have other modern instruments for sovereign debt. The 1944 Act can now be rolled into a Public Finance Management Code. This is done. The law is obsolete, needs a complete repeal. Category A. Now we come to category B. What are these laws? These are partially obsolete or can be consolidated or can be restructured. This is the law that has good bones, but it needs renovation. So, like a house, the house itself is very beautiful, very strong, but the kitchen or the bathroom in the house needs fixation. So, the example of it is the NI Act, the Negotiable Instrument Act of 1881, or like I discussed, the Payment and Settlement System Act of 2007, the Sale of Goods Act of 1930, the Patent Act, and the Indian Contract Act, which we are going to discuss in a few of the slides. So all this is how you need this law to be redrafted or restructured. They are not obsolete completely. They are still relevant, but they need to be restructured. This is category B. Now we talk about the third category, the last category, that is category C. This law is absolutely fine, but it needs some modernization or some monetization. It's like a car, it just needs regular servicing, right? You've taken a car, it's still fine, it is absolutely correct, but it just needs regular servicing from time to time. So targeted amendments, periodic reviews, digitalization of specific provisions. For example, the LLP Act of 2008, the Land Acquisition Act of 2013. These are modern foundational frameworks. The job here is just to maintain these laws. There's no surgery that needs to be performed. So these are the three criteria that we talked about. A, completely obsolete. B, needs some restructure. 3, that is the C, it just needs to be modernized. So this is the output of ODF. This is how the ODF has come out. Now we come to the next slide and we talk about sector by sector. Right? And I'm not going to discuss all the 12 sectors here, but the major chunk of sectors that we came up during the study. Right? I'm going to discuss or walk you through what we found sector by sector. Not 12 here again, I'll do 2 or 3 where findings are most striking. First one being banking, because this is where our CAs feel obsolescence most acutely. The headlines from our practitioners that we discussed, the 137 stakeholders that we talked about, I quote one of them directly. He immediately said, a digital first overhaul is due. A digital first overhaul is due. The strongest signal came against the Credit Information Companies Act. 91% of the respondents said it needs full reform. Why? Because the credit decisions today are being made by AI on alternative data. What is this alternative data? Your phone usage, your e-commerce history, your UPI behavior. The CIC Act, the Credit Information Companies Act, was written in 2005 for a world full of paper credit bureaus and CIBIL scores. Now that world has completely changed. Quick question is just that we all may have seen a client who has been put to court over a Section 138 check bounce case in last 2 years. And how many of those cases were resolved in a year? I think very low. That is the second biggest finding which we come up to in this sector part. Section 138 of NI Act criminalizes check dishonor. Brilliant in 1988, Definitely. But today it has created millions of pending criminal cases for what is essentially a civil debt recovery problem. Practitioners, which we discussed with, told us give us a civil ODR alternative, online dispute resolution. Fast, cheap, no criminal record needed. So, this is the second law that we talked about. The third that I am talking about is FEMA, Foreign Exchange Management Act. Again, misaligned with crypto, cross border e commerce, and current FATF norms. Indian companies doing legitimate global trade get tripped up because the law uses a 2000 era categories. Similarly, as I mentioned, Payment and Settlement Systems Act. It is pre UPI, it needs replacement. So, all in all, our recommendation we build one consolidated digital financial infrastructure code. Bring together the PSS Act, parts of the Banking Regulation Act, the CIC Act, and the modernized FEMA. Make it ready for the CBDCs, fintech, and platform finance, thereby keeping the interface clean with IBC. Moving to the next slide, we talk about sector 2, the corporate and the company law sector. The corporate, company, and fiduciary laws. Now, sector 2, this one is a little tricky. It's messy in a way every CA in this room, I'm sure, will recognize. The Companies Act of 2013 is having an identity crisis. It thinks it is the only law your company needs to follow. Meanwhile, and listen to this, SEBI is calling. The IT Act is texting. The CSR rules are emailing. The IBC is sliding into the DMs, and the income tax department is ringing the doorbell. Now, coming back to the serious point, all five of these regulators expect overlapping compliance from the same audit. Our practitioners flagged this overlap as number one corporate law headache. Now look at the older statutes in this cluster. We'll discuss about this. The first one being Societies Registration Act of 1860. Yes, 1860. When this law was written, the camera had just been invented. We're using a colonial era statute to register modern, not for profits, civil society organizations. Yes, some research bodies even. 81% of our respondents that we discussed wanted a full complete overhaul. So this is the Society Registration Act of 1860. The next one is the Trust Act, again of 1882, a Victorian framework that completely misses modern fiduciary structures, CSR trusts, and a digital asset trust. The next one being the Partnership Act of 1932. Again, outpaced by GST, by digital banking, by online MSME structures. Similarly, coming back to again the Companies Act, Section 2, Clause 42 of the Companies Act, the definition of a foreign company, here we have proposed a digital nexus test. Similar to what US Supreme Court did in the Wayfair tax case, if a company is doing systematic digital business in India, it has a nexus. We cannot deny that fact. So, all in all, our recommendation for this sector was build one organization code, bring together companies, LLPs, partnerships, societies, trusts, and multi state cooperatives with sub regimes for not for profits, thereby making Section 245 the class action provision. Opt out instead of opt in. Regulate third party litigation funding, which is a coming wave. This is consolidating the five gym memberships that I talked in the starting into one membership, right? So, consolidating it together. Now, moving to the next slide, that is the third sector that we talked about, trade, commerce, and industry. The third sector that we talked about, trade, commerce, and industry, This is where our Indian Contract Act lives. This is where we have applied that ODF. Now let look at the table on the screen. Seven major statutes, each one with the category A, B, or C that we discussed earlier. First one being the Indian Contract Act of 1872. It falls into category B. Now remember what was category B? It was laws which are not completely obsolete but needs a little restructuring. 1872 Act of Indian Contract. The law is older than Bollywood itself, older than railways modern network, older than the light bulb being commonly used. And it still governs every single commercial contract a CA touches. The foundational doctrine offer acceptance, consideration, capacity, free consent, all this is intact. But we don't need to throw it away. The law has nothing to say about the modern concepts. What about the modern e concepts? E contracts, smart contracts, algorithmic trading, or AI generated agreements. We will have to fix that. We try to do that in our application, which will come in the further slide. That is, we have tried to make it the ODF applicable and change it, make the reforms or the changes in the Contract Act. Coming back to the topic, the second one that I discussed, the Sale of Goods Act of 1930, again a category B. Written for physical goods, say for example, sack of rice, cloth. Today, however, we sell digital goods, we sell softwares, licensing to softwares, subscriptions, NFTs. The act here in the Sale of Goods Act has no concept of what a digital product even is. The definition of goods, delivery, and title needs updates for the platform economy. Similarly, the third one is my favorite, that is the Essential Commodities Act. Again, an act of 1955. Again, a category B in our framework. It is still actively used as a price control tool every time the prices of vegetables go up. However, written with 1950s wartime thinking, government tells the market what to change. Practitioners told us that this act is fine in principle but needs a much narrower, more predictable scope so business does not get blindsided by sudden invocations. This is a perfect match for our category B. Right? So the other statutes in this cluster, like Competition Act, is category C. Fundamentally sound, just needs a little tweaking here and there for digital marketing amendments. Similarly, the Industries Development and Regulations Act of 1951 is also category B. The FTDR Act is category C. It is functional for WTO compliance. So in this cluster, 5 restructures and 2 modernizations are required. Moving on to the next slide, that is the other 2 sectors, sectors 4 to sector 6, that is infrastructure, IP, and other miscellaneous structures. Infrastructure first. Since we've mentioned infrastructure, we'll talk about infrastructure first. Infrastructure laws include the Land Acquisition and Rehabilitation Act, Arbitration Act, MMDR Act, National Highways, Metro Railways Act, other acts. Most are category C. They are foundationally good. The reform demand is at specific interfaces, not required to be completely repealed or revamped. Say, for example, Section 24, Clause 2 of Land Acquisition and Rehabilitation Act interfaces with other laws, right? The triple P and digital tolling and consolidation of multiple metro statutes into one urban mobility code. So this is for infrastructure. Now we come to the next one, that is the IP. That is IP, IT, and digital. This is a one big dramatic cluster. The IT Act of 2000, 83% of our respondents said it is inadequate for AI, platform harms, and smart contracts. The law was written when most Indians had not seen a computer. Even though it has been changed, there has been further amendments, but we are still talking about making it complacent to AI and platform harms and smart contracts. We are actually talking about AI making decisions on loans, deepfakes, open AI style large language models, content moderation, platform liability, etc., none of which the current act even anticipates. So, this is for the IT part. Now, the third is the Patents Act. Section 3, Clause D, Section 3, Clause K are creating friction for AI inventions and biotech. We are not arguing about whether to grant these patents. Rather, we are saying the law should at least know what to do with the question. What is it exactly that we have to do it? Similarly, like Patents Act, the Copyright Act of 1957. It also needs updates for digital rights management, NFTs, and AI generated content. So these two statutes here out of the entire bucket have mattered. Similarly, the last from the miscellaneous bucket, we were dealing with two sectors, two to three sectors, where we discussed IP, infrastructure, IT, and digital. Now, the last bucket, that is the miscellaneous bucket. The miscellaneous bucket has different laws. Say, for example, the Indian Stamp Act of 1899. It is fragmented across states. You sign a contract in Delhi, register it in Mumbai, enforce it in Chennai, three different stamp duties, three different procedures, three different timelines. Welcome to interstate commerce, right? This single fragmentation is blocking interstate commerce in a way few people fully appreciate. Every cross border digital agreement gets stuck on stamp duty. We propose here in this study a digital document authentication code, one unified standard replacing the patchwork. The clearest category A candidate overall that we talked about was our Public Debt Act of 1944 that needs to be done away with, no requirement of it to be kept. It was functionally superseded in 2007 but never formally repealed. 18 years later, it's still on India's code. We propose to repeal it and cleanly roll it into a public finance management code. So, with this, we are done with the discussion of the sectoral reforms. Now, moving on to the next slide, that is how we applied this ODF finally to our point. We discussed here what was ODF, what was the background, how are the five criterias and tests laid down, what were the 12 different sectors that we measured ODF from. Now we come to the results. We diagnosed that this was the outcome. This is the thing that we got from the entire project, the entire procedure. Now, from diagnosing the problem, we've now discovered the problem, which laws are problematic, which laws need to be repealed or restructured. Now, how do we do it? So, in order to give a sample, we have redrafted or put some new provisions or put some provisions under this ODF to Indian Contract Act. I walked you through all the study, but here's the question that any sensible person can ask. Okay, but can you you've given a beautiful framework, beautiful analysis of the ODF, but can you actually do something with it? Or is there any other academic exercise? All right, so to this question that we have asked, I have given now one category B of the law. That is category B, Indian Contract Act that we have taken. Fully drafted reform is what we have put in this project, and we chose the Indian Contract Act 1872. Why? Because it is foundational. Every audit engagement letter, every MSME supply contract, every fintech term of use, every M&A document, they all rest on Indian Contract Act of 1872. Again, reminding you, it falls in category B. So not completely obsolete, rather needs restructuring. The first was why we took Indian Contract Act, because it was foundational. The second reason why it took was it is misaligned. How misaligned? How did we come to this? 42% of our practitioners that we discussed with said it does not address e-contracts, smart contracts, and AI driven agreements. 47% said its provisions have lost relevance in the digital era. And finally, because there are reform grounds or scope of reform in this. The foundational doctrines of the Contract Act, like consent, consideration, breach, it's very sound, it's very strong. We don't need to repeal it. We just need targeted modernization of this category. So we don't need a complete revamp of this law, rather we just need targeted modernization, like I said. Now what is this modernization that we did with the Contract Act? This I have discussed in the next slide. All right, now we talk about the four reform thrusts, four pillars or four chapters which we want to highlight, where we have made the changes as per the ODF to the Contract Act. Right? The four pillars that we have changed. The first pillar on which we have changed is the first pillar being digital age definitions. We fix the basic vocabulary of the law. What is what is consideration in a smart contract? What is an autonomous digital system? Who can enforce a contract as a third party beneficiary? And can a 17-year-old, a minor, entering into a binding contract can be done for an edtech course? Right? All these questions are the first pillar. That is changing the basic vocabulary as per the digital age. The second pillar on which we have made the changes of the Indian Contract Act is consent. What is consent in algorithmic markets? We modernize the doctrine of free consent for a world of dark patterns, recommendation algorithms, and AI driven nudges. When is consent really free, or when is it really manipulated? I'll explain you this with an example when we further break up the changes that we have brought about in the Indian Contract Act. So this was the second pillar, that is the consent part. The third pillar on which we have made the change in the Contract Act is breach, cure, and hardship. This is the most practical and important reform. We introduce India's first statutory right to cure. We've codified foreseeability of damages, and we have added hardship relief for unforeseeable supervening events. This is the third pillar. I'll discuss all of these pillars one by one to make you understand more easily. The fourth and the last pillar is damages and liquidated damages. This is where the actual changes directly speak to the CA practice. 60 years of confused Indian case laws on liquidated damages. We have tried to resolve it with bringing in two clean amendments. Firstly, whatever these clean amendments are, we'll discuss one by one. Let me take you through these each thrust in one by one. So the next slide talks about the first and the second pillar that we are going to discuss. The first and the second pillars of the Contract Act reform. The first one is digital age definitions. Now imagine you book an Ola or an Uber. You have booked an Ola or an Uber. The cab confirms automatically, right? The payment is auto deducted at the end of the ride. Nobody actually signs anything. Is this a contract? Now, if you talk about Indian Contract Act, does it talk about it being a contract? So we promote, this is where we propose the amendment. We propose amending the definition of consideration to expressly include automated digital or technological means, which includes algorithmic process and authenticated digital or asset transfers. That ends the debate on whether smart contract self execution counts as a valid consideration. Simply answering it, yes, it does. The next thing which I talk about is the new sections that we will introduce, that is section 2 clause K, L, M and N. We propose statutory definitions here first of autonomous digital system, automated performance, external data, which overall covers the oracles and APIs, and also, very important, algorithmic manipulation. These definitions, we have not done it on our own. We have actually drawn them from the UNCITRAL model on e-commerce and the OECD AI principles along with the European Union's Digital Services Act and DGPRA Article 22. We have not come up with these definitions on our own. Rather, we have referred to big international instruments which have already defined it. For example, Section 2A, third party rights. We codify the right of intended beneficiaries to enforce contracts. Currently, Indian privity rules cause real confusion in family settlements and trust arrangements. We've referred to Professor Shiv Prasad Swaminathan's research that he has called this as the Great Indian Privity Trick, a 100-year misreading of 19th century English law. We tried to correct it. So, this is one thing. The next thing that we tried to change in this is Section 11A. We all might have studied the famous Mori Bibi case. Minors contract. This is one of the most important reforms. For example, tell me something. A 17-year-old in India can have a YouTube channel earning lakhs every month. He can be the brand ambassador for a startup. He can have followers across 40 countries. But he cannot enter a binding contract. Does it make sense? He can have a YouTube channel earning lakhs every month. He can be a brand ambassador for a startup, but he still cannot be entering a binding contract. Does it make sense? Coming back to the 1903 Privy Council decision in Mohri Bibi that made all minors' contracts void ab initio. The recent scholarship, particularly Swaminathan and Surana in the Statute Law Review of Oxford, has shown that this was a transplantation error. The pre 1903 position was different. We propose replacing the same void ab initio with voidability plus restitution. Here, the minor's contract is voidable at the minor's option. Benefits, however, unjustly retained must be restituted in equity. This restores the pre 1903 position and at the same time unlocks beneficial contracts in education, digital services, sports, and entertainment. So, this is the criteria for the minor's age. Now, this was the first thrust. That is the first pillar that we discussed. The second pillar in the same slide is consent in algorithmic markets. Now, this is very interesting. I'll give you an example from your life. You know how Amazon keeps you showing, say, for example, you went on Amazon, you looked at a watch that you wanted, and after 3 minutes, now you open some other app, say, for example, a social media app, Instagram or Facebook, and on every website afterward you visit, it follows you everywhere. You are able to see that watch everywhere, or you are opening a news website or trying to read an article, there is a pop-up of that same ad. You're looking at that Amazon watch everywhere, it follows you everywhere. At some point, that crosses from marketing into manipulation. The question here is, where is that line? Where is that line? So similarly, we have done this with the Indian Contract Act. Section 13, consent redefined. We added an explanation that says consent is not free when acceptance through automated means is materially influenced by algorithmic manipulation, informational asymmetry, or automated decision making that a reasonable person cannot meaningfully assess. Similarly, for section 18, undue influence, also, we have added a new limb, technological dominance. This means exercising control over digital architecture or data flows or decision locking. Right? So the Supreme Court has also in Central Inland Water Transport versus Brojonath Ganguly already accepted that economic dominance can vitiate consent. Dominance can vitiate consent. So on those same lines, we propose extending the same logic to technological dominance as well. Similarly, we have made different changes to different pillars where we have changed expanded the definition of fraud. We have reframed the free consent definition. Moving to the next slide, the third pillar that we have talked about is breach, cure, and hardship. What do you understand by nachfrist? There is a concept of nachfrist that we have introduced. Nachfrist in Hindi terms means थोड़ा और time दे दीजिए भैया, right? यानी कि थोड़ा सा और टाइम दे दीजिए. किस चीज के लिए थोड़ा सा और टाइम दे दीजिए? What is it that we are asking for थोड़ा time more? The cure of the problem, right? What problem? Fundamental non-performance. So we have usually three options. Right now, under Indian Contract Act, if your contractor delivers late, your legal options are only three. First option, you can yell at your contractor. Second option, you can cancel your contractor's deliverables. And option three, you can sue your contractor. Now, here we are generating the fourth option. The fourth option is giving a fair second chance. One more chance to the person. And this is not new. Again, let me tell you, this is not from us. This is a German law which has been already there for hundreds of years. There is already a law in place which has been given in Germany, which gives a fair second chance. So we have given it as a fundamental non-performance clause, section 39. Currently, section 39 uses a very vague phrase, refusal to perform. What we have done here is we propose a multifactorial test of fundamental non-performance where we actually judge what is the reason why there is non-performance, substantial deprivation of benefit, foreseeability, proportionality, possibility of cure, and adequacy of damages. Again, this is not from our own. This is based on the Unidroid principle of international commercial contracts. So we are giving the fundamentals, what can be considered as non-performance. And then similarly at the same time, we are also giving a cure for it. Section 39A, Nachfrist cure right. Nachfrist is a German word which means additional period. So the aggrieved party must, by a written notice, give a reasonable additional period for performance. The breaching party then has a continuing right to cure unless cure is impossible or is going to cause an irreversible harm. So that is why giving fair chances has been given, and we have also tried to introduce it. Similarly, we have pushed section 55A, a new section, that is hardship relief. If you sign a contract to supply onions at 40 rupees and in March, say for example, later on, the onion prices hit 100 rupees, right? So here, either perform at 40 and absorb the loss or breach and pay the damages, or we are saying there would be a middle path where performance becomes excessively erroneous due to unforeseeable events, but not impossible. Courts can thereby direct renegotiation, adapt contract terms, or terminate equitably. So, This itself finally resolves the long standing confusion in Indian frustration doctrine between Section 32 and Section 56. All right. So, with this, we have discussed the three pillars, and the final fourth pillar is the Indian Contract Act, which deals with damages and liquidated damages. This is the CA value related slide where we talk about liquidated damages. Today's Indian law on liquidated damages is a little bit problematic. The Supreme Court has also said this same thing in Fateh Chand case and repeatedly in other cases like ONGC versus Pipes, Kailash Nath Associates case, and each judgment has said something slightly different. So, while auditing, you may have had a contract that creates a provision for uncertainty, specifically because you weren't sure whether liquidated damages clause would hold up in a court. This is the cost of legal confusion sitting in your audit working papers. It is real, has a number. What is this number? The number is 23%. Imagine Indian commerce pays approximately 23% premium over comparable jurisdictions because of this one mess. No, it's not a typo that I'm talking about. 23% is absolutely the cost of legal confusion in cross border commercial contracts. So, all these things that we have put forward in the Contract Act have come up, and we have made different changes in liquidated damages reforms and other things. We have diagnosed for changing in the Indian Contract Act and other laws as well. So, moving to the next slide, that is the diagnosis from drafting. It is also a part why it matters strategically, what has happened. All this we have discussed in great detail, right? The Indian contract draft actually took us approximately 6 to 8 months, and thousands of members are already there in ICAI. If it were to replicate this study, then it will be a huge change, and we can do a definitely policy change to it. It will be wonderful. So this change in contract act, it's just not a wish list. It is not that we recommend something, rather it is fully drafted statutory text. We have drafted clause by clause legislative language ready for the law commission to circulate. Additionally, it demonstrates that our ODF produces output, not just analysis. We diagnosed using the 5 criteria. We classified the Contract Act as a category B, then we delivered the redraft. That closes the loop from diagnosis to drafting in one project. The framework works absolutely. And finally, we will look at the replication list on the screen. These laws need different types of restructuring. The say for example, the Sale of Goods Act 1930 needs digital products definitions and platform economy updates. The NI Act, there has been a lot of discussion regarding it, needs a civil recovery rewrite. Indian Stamp Act has to be replaced with a unified digital document authentication code, and so on. So all these change have to made. So handing my the explanation back to Selena ma'am so that she can take it further. We have here shown you 12 sectors. We have introduced the ODF and its 5 diagnostic criteria. We have walked through the A, B, and C classifications. We have presented the sector-wise findings, and we have taken you in detail through the drafted reform of Indian Contract Act. But here's the truth that none of it matters unless it lands on the right desk. None of it will matter if the community itself does not see that and take it forward. That is exactly what ma'am will now take you through as to why CAs sit at the very center of this problem, and why ICAI is the only professional body in India institutionally positioned to operationalize this work, and what concrete time-bound year-by-year action plan we recommend. Thank you so much.
That was really great, Nazir. It was a wonderful presentation, highly powerful, in-depth analysis, lot of clarity, and that too at a time when the people will go for sleep. You have kept them alive and awake with your real life examples and all. And I found that, the whole research is because of this passion which you have shown from the very beginning, and that passion was very much visible in your presentation too. So that was really great, Nazish. So coming back to what I'm supposed to do. So Nazish has explained you the whole work which we have done, like even giving you a draft model of the Contract Act. She has explained everything, how difficult it was to come up with that obsolete diagnostic framework, the field work they have done, the output of the research. Instead of presenting in the traditional way, like research findings, conclusions, and all, Nazish has she explained it like a story, that what all things we have done. So, as she rightly pointed out, now we have completed the work, but it should not be the end. It should just be a beginning. And what we are giving to ICA, and the opportunity, of course, you have given us by funding us and by continuously guiding us from here, how it should be taken ahead further. So let me put it in this way. Every obsolete economic or commercial law in India lands on a CA desk before it lands on a court's docket. I think the CA fraternity will agree with me when I say this. Every economic or commercial law lands on your desk before it lands on a court's docket. So the 4 areas of CA work are directly affected, like the complaints practice, the audit and assurance, insolvency, and restructuring. And of course, even on the digital transaction advisories. So what we have done is we have mapped these points to the CA practitioners. So see the table, this table lays it out concretely. Each row is a statute, each row is a pain point CA raised in our survey, and each row is the practical benefit of the ODF-driven reform which we have proposed. See, the Companies Act overlap, faster complaints and lower audit risk ambiguity is there, LLP Act, procedural friction, cleaner MSME entity choice, MSME delayed payment weaknesses, a real recovery tool, the Stamp Act state fragmentation, unified digital document authentication, FEMA uncertainty around crypto, certainty for international tax and treasury advice, IT Act outdated definition, as she has given the example also, smart contract recognition, the UPI architecture, clarity on payment client risk, Negotiable Act, Section 138, faster commercial recovery via civil and ODR routes, Contract Act, e-contract gaps, predictable advice on highly unpredictable to say. So every one of these is a direct day-to-day improvement to CA practice. What all suggestions or what all the outcomes which we have come up will daily, we hope that it is going to be a day-to-day improvement on CA practice. None requires the legislature to invent anything new, and the international templates already exist. So what the CA profession, the CA fraternity, what you will be able to do with the research which we have framed. For an individual CA, a clearer complaints map. For an CA firm or practice, an institutional advisory product. For ICA as an institution, you can be or you should be a national policy voice, a continuous statutory observatory powered by the ICA network, an annual ICA Obsolete Index, visible, citable, government-facing. You direct structured input into Niti Aayog, Law Commission, and Ministry consultation. I'm re-emphasizing it. The project should be carried on from here by ICA as a national policy voice. You should be the continuous statutory observatory powered by the ICA network. You should be able to come up with obsolete index annually, visible, citable, government-facing, direct structured input into Niti Aayog and Law Commission, and of course for ministry consultation. So this is a very highly strategic positioning for ICA. So we are also coming up with some reform pathways, and it has 4 strategic clusters. The first cluster is Digital Financial Legal Framework, consolidating RBI Act, Bank Regulation Act, the PSS Act, FEMA, and the CIC Act. So the findings of the study, and it should not remain on the paper, how we have to implement it. And for implementing the findings of the study or the obsolete diagnostic framework which we have developed, the ICA, or we are suggesting that you should come up with 4 strategic reform cluster. The cluster 1 on digital financial legal framework, cluster 2, a consolidated organizational code covering LLPs, the companies, partnerships, societies, trust and cooperatives. And in the cluster 3, we proposes all this land infrastructure logistic code repealing the Carriers Act. And in the cluster 4, of course, it is the institutional architecture for obsolescence management, embedding the ODF into Niti Aayog and Law Commission workflows. And all these things we have very detailed put in our chapter 4 of our report. Then I'm not going into I think paucity of the time is also there. The cluster 1, digital first financial framework, we propose a code that brings together a modernized RBI Act, fintech and data. There should not be any overlapping. The payment and settlement system should be replaced, and we should follow the FEMA modernized for crypto cross-border e-commerce. The Credit Information Companies Act, we have to ensure that it is in alignment with the open banking and personal data protection. Similarly, SARFAESI and RDB provision should be in par with IBC interface. The outcome which we are suggesting is a rule set for the UPA era, a single technology neutral statute. Instead of having multiple statutes which overlaps and which is inconsistent with each other, creating multiple jurisdictional forums, which gives the client and the auditor forum shopping or confusion as have to go ahead, we are suggesting a single technology neutral statute. And we are suggesting that, you can follow some best practices of Saudi 2018 bankruptcy law, the UAE 2021 Companies Act, Singapore sandboxing rule, as she has already explained what it is, and EU one in, one out, the UK and the US sunset review provisions, which we have discussed in detail in the chapter 2 of our report. Keeping that as the best practices, we should move for a single technology neutral statute. Then coming to cluster 2, an organizational code. The organization code, it consists of 6 current statutes: the Companies Act, LLP Act, the Partnership Act, Society Registration Act, the Trust Act, and the Multi-State Cooperative. This is the major code that governs the organizational behavior of a corporate structure. So, in that, there are certain particular provisions, as she has rightly pointed out, Section 2, Clause 42, Section 245 on class action or third-party litigation funding, Section 100 to 169, then mandatory incorporation, virtual governance, technology. There is a lot of inconsistencies and overlapping between these codes. So we should come up with one organization code which will have one complaints playbook across all forms instead of having multiple statutes. Then coming to cluster 3, land infrastructure and logistics. This is not that important from a CA perspective, but still from the client perspective, it is important. As we know, the land and acquisition infrastructure, logistic and carriers, we have many regulations to say, and even it is state-wise regulations when it comes to land acquisitions and all. The land, we have now the National Highway Act, hybrid annuity model, toll operating transfers. So it is high time to repeal the Carrier Act of 1865 and coming up, and we have to come up with a single logistic act which addresses the need of the time, addressing all the technological changes which we have. Now, coming to the institutional architecture, we need a 5-step process. And it is, of course, linked mechanism. See, a mandatory regulatory impact assessment for every significant new economic or commercial law built around the ODF's 5 criteria. Then we should have statutory sunset clause in every provision. We should have periodic stewardship review. We should have structured stakeholder output, and we should have an annual obsolescence index. This is the most important part. And if this project which we have done should have a meaning, or it is going to add on value to the existing research, these are the 5 things which we have to ensure. That is, there should be a mandatory regulatory impact assessment, just like how the environmental law have the environment impact assessment. And like whenever we start any industry, we have to ensure that it is not causing any damage to the environment. Similarly, every commercial law, every economic law should do this impact assessment. Then every statute should have the sunset clause, every statute should go for periodic stewardship review, and every stakeholder input should also be there. So we want to we want to request ICA that ICA is the best place to lead. I want to pause here and make case for ICA specifically that why ICAI the right institution to take this work forward. Of course, your motto that even when others sleep, you have to keep awake. So you have a huge responsibility, and as rightly pointed out by our Honorable Prime Minister, you have to take up the next the next freedom struggle of India, the economic freedom struggle or the economic renaissance. So ICA has the largest practitioner base touching the commercial law. No other professional body in India has equivalent practitioner data on what works and what doesn't. Secondly, ICA is statutorily independent. ICA has a national network. ICA is already respected policy interlocutor. ICA submission to the Minister of Finance, MCA, SEBI, RBI are routinely cited in committee reports. So our ODF diagnostic framework or our project summary should be submitted to all these ministry levels or SEBI or to RBI for implementation. And now we'll see the actionable outcomes. Actionable outcomes we are planning in a year. The actionable outcome or the strategies which we have to do, we are planning for a year. The quarter one, adopt. Please publish our report, launch a statutory modernization page on ICA portal, set up an internal ICA working group on obsolete. We also request ICA for the operationalization of our ODF. Train your ICA members as ODF assessors. Open a member survey portal to feed continuous obsolete data and build an ODF scorecard template for client engagement. It should be included in your curriculum. Then public engagement. Submit a position paper to Niti Aayog citing ODF and the Category A statutes. Submit Annexure B to the Law Commission as a draft reform for the Indian Contract Act. Please host roundtable with Minister of Corporate Affairs, Minister of Finance, and SEBI on the 4 reform clusters which we have suggested. And of course, the final thing, annual obsolescence index. Release ICA's first obsolescence index of Indian commercial statute, followed by annual obsolescence index. Then our proposal is for a national scaling program. In the next 2 years, in the years 2 and 3, we propose 6 scaling actions. Establish a dedicated ICA Center for Regulatory Reform. Please work with the ministries on sectoral reform codes. Third, a continuous practitioner dashboard, an international comparative network, and finally, an ICA specialization track on statutory modernization and regulatory reform. We also suggest that ICA should come up with a cadre of regulatory reform experts. How do we build this cadre over the 3 years? For that, we have a plan. We are coming up with a strategy. In the stage 1, identify 100 ODF trained member, scaling to 1,000 by year 3. Each completes a structured ICA CPE module on applying the ODF to a sectoral cluster. And in the stage 2, deploy the ODF scoring programs as routine complaints, audit advisory engagement. And in stage 3, specialize senior CAs accredited as regulatory reform experts, public-facing commentators, policy paper authors, committee witnesses on behalf of ICA. And one more thing, ICA can ask from the policymakers 6 concrete tasks which ICA can now ask from the policymakers, backed by the evidence which we are supporting. First one, recognize ICA as a permanent stakeholder in pre-legislative consultation on economic and commercial law. ICA should negotiate with the government of India, with the Ministry of Commerce, that any kind of changes in economic and commercial law, ICA will be a permanent stakeholder in pre-legislative consultation. Next is, we should make the ODF a mandatory annexure to draft economic and commercial bills under the pre-legislative consultation policy. Whenever ICA is called for any kind of pre-legislative consultation, please keep this ODF as a mandatory annexure. Then the pilot statutory sunset clauses on in the Ministry of Law and Justice, you should consult or you should initiate to have these mandatory sunset clauses. And formally refer Annexure B, our draft contract, to the Law Commission of India. Establish a tripartite ICA Niti Aayog Law Commission working group to operate the ODF and publish the annual index. Integrate ICA's Obsolete dashboards directly into National Viksit Bharat monitoring stack. I don't know whether we are over ambitious or not, but if the project which we have undertaken, leave this particular project or the research which we have done. But if India has to achieve Viksit Bharat by 2047, ICA has a very crucial role. And in that, if ICA can take up any of these things, it will be really crucial and strategic. I'm skipping few slides. Implementation and roadmap to 2047. This is a 22-year roadmap that ICA in 2026 adopt the report, set up the working group, launch ODF training. Then, after a year, operationalize the live sectors, index publishing, law commission niti engagement. Then legislate, then embed, then sustain. Each phase has measurable deliverables critically requires India to invent new institution. We have included all these strategies in our report also, how to implement it. And let me close by summarizing what ICA now has in hand. Our project, I'm trying to summarize what we have done. We are giving ICA 6 concrete deliverables. 1, the 4-chapter research report. Then an annexure, A, the survey questionnaire across 12 categories. It is reusable one. You can reuse as a basis for continuing ICA member surveys. And 3, annexure B, the working reform draft of the Indian Contract Act. 4, the ODF diagnostic methodology, ready to apply to any statute. And the 5th one, sector-wise ABC classification of 33 statutes. 6, a blueprint for embedding ODF into Niti Aayog, Law Commission, and Ministry workflows. To sum up this slide, or to put it up in another way, this is the contribution of our research to you. That is, we are coming up with Annexure A, the survey questionnaire, which is a reusable questionnaire for on a continuous basis to address the obsolete nature. Then we are coming up with a draft Indian Contract Act. We are coming up with an ODF methodology for you. And we have categorized nearly 33 statutes on sector-wise A, B, C. Those which has to be repealed, those which needs reconsideration, those which needs modernization. And we are also giving you a blueprint on how to implement this obsolete diagnostic framework and how it can be integrated with Niti Aayog, Law Commission, and Ministry workflows. I want to leave you with 3 thoughts. We have collected evidence of 137 practitioners, 12 sectors, took the best best practices of 8 international jurisdictions, 1 unified framework. And the instrument we used is a replicable diagnostic ODF framework, which can run for next 2 decades. And the opportunity is ICA can be the permanent seat for the table of national legal regulatory reform. Viksit Bharat 2047 will be built on the statute book. ICA member will be the one writing the audit note on whether it will work. Dear CA fraternity, as someone who has worked with many regulators and professional bodies, of course, working in a university, I know how the other regulators are there. I have seen UGC working, the Bar Council of India working, National Medical Council working, AICT working, but I vouch that this with complete sincerity that ICA is different. Most regulators are content to police the complaints only. But you chose to shape the future. It regulate, yes, but it also researches, questions, mentors, experiments. Through the vision of its council and the leadership of the research committee, it has quietly built a living ecosystem of knowledge, commissioning independent projects, encouraging young scholars, instituting research awards, and inviting universities into genuine partnership. This is your leadership. And it is in the larger journey our modest project finds the true meaning. Just as Honorable Prime Minister's 2017 call to the CA fraternity, you took it with rhetorical flourish. You took it as a mandate by asking a simple but brave question: which economic and commercial law no longer serve as Viksit Bharat, and how must we reform them? I say shown that it understands the deeper implication of the powerful signature. Our work is only one small thread in the larger fabric that the Institute and the profession are weaving, a fabric of modern, current, future ready laws on which the signatures of India's chartered accountants can rest with complete confidence. With these words, let me close my presentation. Thank you so much to Dr. Mitali, Dr. Ms. Poonam Tyagi, and all the members of the research committee, chairman and vice chairman. Thank you so much.
Thank you, Salina ma'am and Nazish. It was really a wonderful and insightful presentation given by both of you by sharing the research insights, and trust me, the hard work which goes behind coming up with such a challenging research really takes a toll on it. Plus, the kind of work you have done where you have used the techniques of replicable ODF framework, which is again a very important tool for this research. And I'm sure that the recommendations or the suggestions which have been proposed in the research, though they are not of the nature that we said we should say that it should be followed, but they are the proposed recommendations rather. They are the proposed recommendations by the research which you have brought in out. So I'm quite sure that it would have been really encouraging for all our members also to come up and share their research proposals and can have an engaging research work. And now I request Dr. Ashok Mishra sir to please propose a vote of thanks. सर आप म्यूट पे हैं.
Sorry. So let me do the only part that I can tell you that I will start in a different way. Mr. President, Vice President, ICI, both in absentia, Secretary ICI, Mr. Batra, CA, Mr. Bisal Doshi, also in absentia, CA Pramod Jain, who is the vice chairman of this committee and has written multiple books on limited liability partnership. That's why I know him also. And still, he is in the council and helping the chartered accountants how to come out of the vicarious liability, because these are all attached to the CA Act. And let me tell you, Dr. Mitali Phatak, you have done a marvelous job by giving this assignment to the Jamia Hamdard University. So, at some point of time, you were doubtful what type of report they will bring. But see, the team here is so well versed in this, and with even the international exposure to them, to Salina ma'am, and Naji having a deep experience of teaching, getting involved in the study, interactive sessions, organizing multiple programs, that they have presented your report covering a marathon of issues which you respectfully can always submit to the government after going through your procedural requirement. So and so many issues are there. They have also pointed out to you obsolete laws are not only creating the problem for the industry, they are also creating the problem for the government. As a chartered accountant, one will be very clear wherever the law is creating some lacuna, they will use some other law that has not been repealed. And even in our country, we are not repealing the Finance Act. Whereas in Japan and other country, as soon as new Finance Act come, old Finance Act is already deemed repealed. So there are so many things, and they have pointed out how they have processed through the various study. This will be of much help to the students, particularly to our article clerk, audit clerk who are involved in this profession, and also to the chartered accountants who can use to as a professional colleague. I can always tell you that you can use this drafting once you will have to go through. Actually, if you read once, you may not be able to justify or tell what type of report is this. You will have to read 2 3 times, then you will understand the concept, and then you can progress and you can use in your practical life also. I will suggest through Dr. Mitali Pathak and CA Mr. Pramod Jain that they can also give to Jamia Hamdard for reconsideration of even the Chartered Accountant Act 1949, because it is such an old act, and it has also taken a format of virtually obsolescence, because with the NAFRA coming into picture, so many regulator coming into the picture, it will be a great thing if you think of for reviewing also from the various punishment, because punishment flows from this act. This is not a separate act that gives you, because it is your schedule 1 and schedule 2 which is the only building the cases against the members. So I think, considering the performance of this report, you will like to recommend, and I am particularly thankful to Dr. Mitali Pathak, who reposed confidence in me and agreed to assign this project to Jamia Hamdard University. Now she herself can assess how the strong team we are having. Since we are an infant law school, so it will take some time to build up that particular type of image. So with this, and I am particularly thankful to Najis Fatma also, who has gone through the full project report, how she has prepared because under the guidance of Salina ma'am, and how she has taken you through multiple laws. Salina ma'am being the dean and having a deep expertise in this, including international exposure of Saudi government in Ministry of Higher Education. That's why she has also taken up this report in an international standard, so that people should not blame Charter ICAI that the report is in a particular format. With all this, I thank to all the team members of Dr. Mitali Pathak and team for cooperating with us. And now request will be that only they should release whatever the balance payment is left over and assign some new project to Jamia Hamdard. Thank you, Mitali, and thank you,
Thank you,
Salina
sir. Thank
ma'am.
you,
Thank you,
everybody.
Najis.
Thank you so much, sir.
Thank you so much. Thank you.
Thank you so much.